Hi, everyone. Welcome today. Thank you for joining us for today's webinar. I'm the POA. Now what? So my name is Beth Cohen-King. I'm the Marketing Director at Margolis Bloom, and we work with our clients to find the best estate planning or elder law solutions for each client's unique situation and goals. So we bring to this effort 30 years of experience, 30 plus years now, and a commitment to providing the highest level of personalized service. So for today, our presenters are Sarah Hartline, Senior Associate at Margolis Bloom, and we've partnered with Tony Madigan, who's the Director of Marketing with Artist Senior Living of Lexington, a memory care assisted living community. And so for just as a heads up, how the presentation is going to go today is really more of a conversation with a Q&A. So Tony's going to be asking questions and Sarah's going to answer, and maybe vice versa, depending on how it goes and if there's any questions that come up. So for all of you, if you have questions during the presentation, please type them into the question box in your control panel on the right side of your computer. And so we're going to have time for it at the end. And if we aren't able to answer everything, please don't worry. We will follow up directly via email. And additionally, if you need to jump off, we're recording the presentation, so we will have that within the next week for you as well, and if you want to share it with anybody else. So with that, Sarah, I'm going to let you take over and give an overview.
Great. Thank you, Beth. Good afternoon, everyone. And I'm very excited to be doing this with Tony on this very important topic. And as Beth mentioned, we are going to try to make this mostly a question and answer session. Please feel free to jump in with your questions. But before we do that, I did want to give a little bit of background information just so everyone is on the same page in terms of the terminology and what we'll be discussing today. So starting with what exactly is a power of attorney, the way I explain powers of attorneys to my clients is to say that when you're appointed as a power of attorney, you're in effect stepping into that person's shoes and acting as that person with respect to financial decision making. So trying to do what they would do if they had the ability and capacity to do so. So as an example, if I have a bank account at a local branch and assuming there's no pandemic going on, I go in to make withdrawals from that account regularly. If I appoint someone as my power of attorney and then I am hospitalized, for example, they now have that ability to step in my shoes as my power of attorney. And basically, when they walk into the bank, they're going to be treated the same as if it was me myself doing so. So they could withdraw funds from my accounts, they could transfer funds, and again, just acting as if they are me. So typically, powers of attorneys are, for this purpose, very broad. We want that person who's stepping in your shoes to be able to do anything that they need to do, whether it's pay bills, sell stock, open new accounts, just because we don't know exactly, in the event of capacity, what powers they're going to need. And there's two different types of powers of attorney. Another important distinction, there is springing powers of attorney and what's called immediate or durable powers of attorney. Springing powers of attorney only take effect when the principal is incapacitated, whereas a durable power of attorney is in effect as soon as it's signed. So if I sign a durable power of attorney today, appointing an agent, that person can right away, again, be able to communicate with financial institutions in terms of accessing information, and also can, access funds even while I'm completely capacitated. So, and as a related note, the reason why, because often one of the questions is, well, why would you want a durable power of attorney if that person can immediately have access to your funds, and you really only need a power of attorney in the event of incapacity. And the reason why is two things. First, that the advantage of having a durable power of attorney is that the person using it won't have to go through the burdensome process of proving the incapacity of the principal. And second, that there may be times when you actually do want to use your power of attorney, even though you do have capacity. So, for example, if you're traveling and need your agent to sign something on your behalf. And then finally, just quickly wanting to distinguish between powers of attorney and healthcare proxies. This can be a little bit confusing because some states have what's called healthcare powers of attorney. And so that can lead to some confusion, but that's not the case in Massachusetts. In Massachusetts, we have healthcare proxies for medical decision making and powers of attorney for financial decision making. And that can be the same or different people, but they are two distinct roles. And primarily today, we'll be talking about the power of attorney part. So, so with that brief overview, I'm now going to turn things over to Tony so he can introduce himself, and then we can get into some of these questions that we've received and questions that we frequently hear.
Thank you so much, Sarah and Beth. We're really excited to partner with Margolis Bloom to talk about this. As the Director of Marketing here at Artis Senior Living of Lexington, a memory care and assisted living community, oftentimes when loved ones come in to make a decision on whether or not they should move, the adult children move their loved ones into our community, many legal questions come up around what can they do, what can't they do? And what I wanted to kind of bring forward are frequently asked questions of adult children who are deciding to move their loved ones into our community. So I'm going to go down here, Sarah, and kind of ask you some of the commonly asked questions. The first one being, if you could describe for us what the difference between a conservator and a power of attorney is.
Okay, great. And this is a great question, one that frequently comes up because often, as much as we try to emphasize the importance of having a power of attorney, sometimes people don't have a power of attorney. And when they, if they are to become incapacitated, for example, in the event of a sudden health event such as a stroke, the first thing is to see, do they have a power of attorney? Did they sign a document appointing somebody to be making decisions in this type of situation? Or if they don't have a power of attorney and there is a need to access account information, to access funds, for example, to pay for care, then what are the options? And usually the main option is to go to court and have a conservator appointed. And the conservatorship process is, unfortunately, it is costly. It's somewhat intrusive to privacy in that a medical certificate for that person would have to be obtained with very detailed information that would then be filed with the probate court in terms of making that determination. Is this person, really incapacitated, or can they still make decisions? That could be a gray area depending on the situation. And then beyond that, if there's no power of attorney, then it's really the court who is trying to make the decision of who should be the conservator, who should be the person that steps in to make decisions. So recently I had a case where unfortunately, a gentleman, did have a stroke. There was multiple children, and there, ended up being the situation of who is going to be. Everyone had different opinions, and so the conservatorship process ended up being very drawn out and unnecessarily expensive because of the fact that in advance that the father hadn't made that decision to say, this is the person that's going to be my power of attorney. This is the person that's going to make decisions if something happens. So hopefully you don't need a conservator appointed. Hopefully you do the power of attorney, and then you avoid that process.
That's great. Thank you. That's a great answer. My second question I often get asked is, how long should I, if I am the power of attorney, how long should I be keeping financial documents?
Great. That's a good question, and I think also sort of it leads to another question in terms of not only how long should you be keeping records, but also record keeping, which is very important as a power of attorney. So as an agent, you are fiduciary, which means that you have under law what's considered the sort of highest highest duty that you can have in terms of your acting loyally to your principal and making sure that there isn't any type of, for example, commingling of your personal funds with the principal's funds, or any type of, you don't want to ever be in a situation where you can't account for a withdrawal, for example. So very important to keep accounts very segregated to the extent possible. You don't want to be paying for things with, for example, your personal credit card and then reimbursing yourself with the principal's funds, although that can be done. To the extent that you can keep the accounts completely separate, keep detailed records in terms of what things are paid for, and what the purposes are, and then in terms of keeping records, a little bit of this, there's no sort of hard and fast rule, and luckily today a lot of things are accessible online. So for example, bank statements, so you don't have to actually keep hard copies, but we generally say 5 to 7 years. 5 years, if the person ever did need to apply for Medicaid, they generally need 5 years of records, and then for tax purposes, the general rule is 7.
Great, thank you for that explanation. I'm serving as power of attorney for my loved one. Can I reimburse myself or give myself payment or compensation for serving as their power of attorney?
That's a great question, and that's another one that definitely comes up often. So often the power of attorney is a child, and that child may be spending a significant amount of time, for example, doing these things I'm talking about in terms of dealing with the bank, setting up accounts, paying bills. They might be taking the loved one to doctor's appointments, spending a lot of time having to take time off from work. This is, could potentially be a very serious time commitment. And so, an example where, in a situation where there's, multiple children, for example, can that one child that is serving as the power of attorney reimburse themselves, for example, for gas, or pay themselves some sort of salary or hourly compensation for that time that they're putting into it? And the answer is yes. Certainly, you can reimburse yourself, as I said on the previous question, to the extent that you can pay for things directly out of the principal's funds. That's always preferable to, for example, charging something on your own personal credit card. But certainly in a situation where you do need to pay for things, you can reimburse yourself. Just keep very careful records. In terms of the payment for compensation, that one's a little bit more complicated, just because, again, very dependent on your situation in terms of, so in this example, if there's 2 other siblings, are the siblings, are they on board with you getting paid, or are they potentially going to have a problem with that, and potentially bring that up in terms of being a potential violation of your duties, depending on how you're compensating yourself. So I would say it does depend a little bit on that in terms of what you want to do, how careful you need to be in terms of setting what the hourly rate is going to be, how careful you are going to be about keeping records in terms of what you do. I mean, certainly the most conservative option is to keep very detailed time records of any time that you're spending doing anything as your power of attorney, and then using an hourly rate that's reasonable based on the types of activities that you're doing. If you're driving them somewhere, if you're driving the loved one somewhere, what would be the price of paying someone to do that is kind of where you want to be thinking. So yeah, so that's sort of in terms of the situation with siblings. And similarly, if that person is at some point going to apply for Medicaid, Medicaid also might be carefully looking at payments that are made, especially from a power of attorney to themselves, and making sure that what's paid is reasonable. So again, another reason to be very careful about keeping those records, showing how you come to the calculation of the hourly rate. And finally, just as an additional note, making sure that the power of attorney document itself doesn't have any specific language about how you should or shouldn't be compensated.
Great, thank you. I get that question more often than you would think. Here's kind of a simple one, but if there's an address change, do we need a new power of attorney prepared?
So I think this is actually probably one of the most popular questions that I get. And often this question actually comes up when the person is creating the document. So a meeting with someone, they're appointing, two of their children who are in their 20s as in various appointments, and they're saying, well, they're not going to be, this is, a rental apartment. They're not going to be in this place for long. How worried do I need to be about coming back and signing a new power of attorney to change the address and the phone number? I would say that the phone number is much more important in terms of these documents than the address. The address is really for identification purposes in terms of if you appoint, say, the child, and there ends up being, and this happens in some families where there's multiple people that have the same name, for example. And so we use the address and we use the relationship when we're putting it into the document to make it very clear who this document is referring to, what person. The phone number is important because, especially more so with healthcare proxies, you want to be able to have, for example, a hospital be able to know who to contact and be able to reach out. Luckily today with phone numbers, those aren't typically changing. Usually you have a cell phone number and that just follows you. So sort of that was a very long answer to saying that I wouldn't be too concerned with address changes as long as the document makes it very clear, for example, that this is appointing my son, John Smith, and there's no confusion in terms of if he doesn't have that address that he's the person that it's referring to. But certainly important to have an updated phone number, a way of a person contacting your agent if needed.
Excellent, thank you for that. I just recently had in 2 adult children, and I guess they would be categorized as joint agents. So how does it work if there are 2 joint agents? Do they have to agree on everything?
That's a great question, and the answer is one of what I would say is an attorney's favorite answer to a question is it depends, and so it definitely depends on this situation, and it actually mostly comes down to the document itself. So if you look at the power of attorney when it is appointing multiple people, there should be language that says in the document that they can act jointly and severally, or if it doesn't say that, the assumption is that they do have to agree. So, for example, our powers of attorney do usually say, if it is consistent with the person's wishes, that, for example, if there's 2 children appointed, that they can act jointly together, or they can act severally, which means either of them can, for example, go into a bank and communicate with that bank or make withdrawals without having any sort of assent or sign off from the other agent. That said, we do see a lot of financial institutions get really, they get nervous about this type of language, even if it specifically says that either of the agents can work by independently. They might say, we really just want both of the people to sign off in terms of any transaction. Definitely, for example, with sale of real estate, the title insurance company might want both people signing off. And I think that this definitely does, go back to the question in terms of when somebody is creating a power of attorney, in terms of whether or not having joint agents really does make sense, because it does overall definitely make the process a little bit more cumbersome in terms of, as opposed to having one individual person. But for some people it is important, for example, if they have 2 children, to make sure that they're both equally involved. So it can make sense, but it's definitely something to consider in terms of when you're making that decision, whether you want that extra potential work in terms of carrying it out.
Great, thank you. I recently had a family that came in for their father, and he did not have a power of attorney, and the father has recently been diagnosed with dementia. How do I get a power of attorney for my father who has dementia?
That another very common question, and this does go back a little bit to the question in terms of the difference between a conservator and a power of attorney, which is that in order to sign a power of attorney, a person does need to have what they call legal capacity, it's certainly a gray area, because some people, in this scenario, for example, the father might have been recently diagnosed with dementia, but he might still have legal capacity to sign documents. So it's not, there's not a clear-cut, moment in time necessarily where a person has capacity and they don't have capacity. But at the same time, again, depending a little bit on the situation, especially if there might be multiple people in the family, for example, that don't agree, it can definitely get tricky in terms of the father signing a document and then maybe the family, for example, questioning whether he really did have the full capacity to do so. So I guess what the takeaway is, the main takeaway is to get powers of attorney, early, when you, before any type of diagnosis, if you can do that. And also in terms of being an adult child of a loved one, is to definitely make sure that not only do they have those documents, but I always tell people, if you are an adult child and you have a parent who says, yes, I have a power of attorney, or yes, I have a healthcare proxy, to actually try to get your hands physically on it. Because we do have people that come in and say, oh yeah, my mom or my dad has a power of attorney, but then they can't find it. And if you can't find it, then it doesn't have any value. So the short answer to the question is, I guess, again, it depends. The father, if he still has legal capacity, could potentially sign another power of attorney. If he is at a point where he does not have that legal capacity, then the family would be looking at doing a conservatorship action instead.
Great, thank you. So it saves a lot of time to have a lot of these things planned out beforehand, is what you're saying.
Right, yes, and then I know it's easier said than done in terms of getting these things done. They're sort of, estate planning is often one of those things that gets to the bottom of the list in terms of not really being a fun activity, but it's definitely, yes, it definitely pays off and saves a lot of time and money in the long run.
So if my father, we got him to sign off, we do have a power of attorney with him, he's been diagnosed with dementia. Can a person with dementia change their power of attorney?
So this one, it's similar to the situation in terms of the person having, getting, signing an initial power of attorney. So again, you do need to have legal capacity, and typically when you execute a new power of attorney, it actually revokes the previous one. There's usually specific language in that. Again, you would be looking at that assessment of, does that person who has dementia still have the legal capacity? If so, then they can potentially change the power of attorney. If not, you're looking at more of a you're looking at the path of going to court and getting a conservatorship. And certainly in a situation where this person now suddenly wants to change the power of attorney after having the dementia diagnosis, that can make it certainly raise some red flags in terms of potential issues that you're going to run into.
Great, thank you. How often should the power of attorney be updated?
So that's a good question really, when you sign a power of attorney, the power of attorney does not have any sort of expiration date. But again, going back to, it's not really, it's about how the document's going to be used. And so if you're trying to use it at a financial institution, for example, that might be particularly nervous or conservative about letting somebody access an account, especially if it's a large account. They often do have internal policies at the financial institution about the power of attorney needing to have been signed within the past 5 years or within the past 10 years, or wanting some sort of additional hoops for you to jump through if it's more than a certain amount of years old. So in general, we do say definitely every 10 years, but with some financial institutions, we're actually even looking at more like every 5 years. It's probably your best bet. And another thing to do is, certainly if somebody is at the early stages of getting a diagnosis, not only having that power of attorney document, like I said, having your hands on it, but also going to the banks or the whatever it is that the place where that person has their accounts, and actually doing the paperwork to establish the person as the power of attorney, so that you can see if you're going to run into any problems. And then at that point, it's not going to be a situation where it is too late, for example, for the person to have to sign some additional paperwork. So I've had that scenario before, where a person has gone and the bank has their own power of attorney form that they want signed. So it's definitely better to run into that issue earlier rather than later, of course. So it does defeat the purpose a little bit, that the bank is making you, sign a new power of attorney if you already have that document. But unfortunately, if your choices are trying to, fight with one of these big banks versus sign a new document, often, you just have to, sign that new paperwork. So again, sticking with the theme of doing something earlier rather than later, it certainly can help to be proactive about it.
Great, thank you. I just recently had a scenario where a son was granted the power of attorney, but the mother said that she wanted to make the financial decisions. The son being the power of attorney, the mother of the husband, wanting to override that. Who's in charge there? Can a spouse override a power of attorney?
So this is something that this is actually somewhat of a misconception, in that people think that spouses automatically have some sort of automatic by law power of attorney, and that a spouse, for example, could go into a bank and gain access to their spouse's account without any sort of power of attorney documentation, any sort of document that's been executed? And the answer is no, that's not the case. And then certainly if the person has appointed a child, for example, as their power of attorney, the spouse does not have any sort of legal authority to override that. Sort of to distinguish, there might be joint accounts that the spouses have together, and certainly both spouses have full access to those accounts. But if there's an account just in, I think it was in your example, the husband's name, then the wife is not going to be able to access that account. Actually, a lot of the work that we do when we do have to go to court to get a guardianship or conservatorship, often we are doing that because somebody, it is often the spouse that's going to court to get guardianship or conservatorship of their spouse, because their spouse, never did a power of attorney healthcare proxy appointing them. So certainly no comment, that is a common misconception, but the spouse would not have any sort of override power.
Okay, great. If I'm a power of attorney, does this mean that I have guardianship of my loved one?
No. So similar to how there's a distinction between power of attorney and healthcare proxy, with power of attorney being more on the side of, or not more, it is the side of financial decisions, and healthcare proxy is for medical decisions. In the Massachusetts probate courts, conservatorship is somebody who's appointed by the court to make financial decisions for somebody, whereas guardianship is the appointment for someone to make medical decisions. So if someone didn't have a healthcare proxy, for example, and they were in the hospital and the doctors needed to be looking to somebody to be making medical decisions, that would be the healthcare proxy. And if there was no healthcare proxy, there would be potentially the need for guardianship, although in the on the medical side of things, there is, when I was just talking about spouses not having any sort of preference, there is more of a system in terms of the hospitals looking to the next of kin, where it would be spouse and then children, in terms of making those decisions when there isn't a healthcare proxy. So they do have more of that priority of rights. That said, still definitely a good idea to have a healthcare proxy, not only because it appoints specifically who that should be, so even if it's a spouse and then maybe a child as an alternate agent, but also because the healthcare proxy can include specific language in terms of what your wishes would be. So it can include a medical directive to say, in the event of X, Y, or Z, what type of care or treatment that you would want to receive. And that medical directive can certainly be very valuable to the agent, who's then put in that position of having to make those decisions, if you are incapacitated or hospitalized. I know personally from speaking, with agents that are facing those decisions, it can be really hard, and being able to have the medical directive, in that own person's words, to say this is what I would want or not want, is really a huge, it lifts a huge weight off of their shoulders to be more confident in the decisions that they're making.
Great. Thank you, Sarah. I'm gonna let you go grab a sip of water, and I think Beth has questions to open it up to everyone else.
Yes, definitely. We've got a lot that have come in, a few through email as well. So we will try to get to them all, as I said before. If we're not able to, and if they're more complicated than a simple response, Sarah can respond at through email at a later time. So I just want to start with one that said, what can relatives, oh, Sarah, did you get your glass of water yet?
I did, thank you.
Okay. So what can relatives do if the POA does not fulfill his or her responsibilities?
Great question. So, and I think we touched on a little bit of this going back to talking about from the perspective of being the power of attorney and wanting to be careful about doing certain things and making sure to to meet your obligations to the principal as a fiduciary, from the perspective of a family member who, for example, feels that the person in that role is not fulfilling those duties, and assuming that the person, the principal, does not have capacity to change their power of attorney. So I guess I'll sort of distinguish two situations. There might be a situation in which a parent has full capacity and they've appointed somebody, and a sibling might not be happy with that choice. But as long as the person has, full capacity, as I tell people, they have the right to make bad decisions, in terms of, you might not agree with some of the decisions that the parent makes in terms of who's going to be serving these certain roles. But in a situation where they've appointed somebody as their power of attorney, they've then become incapacitated, and somebody has taken over in that role, and is not acting in the person's best interest, the person can file a petition for conservatorship with the court, asking that person, that the power of attorney be revoked. And so that is a court action that unfortunately can be costly, timely, and so to the extent that you can try to resolve that without court involvement, or sometimes where we see it come up, the person can even send sort of correspondence saying, can you provide us with X, Y, and Z, or some copies of financial statements to show us what's going on. I find that transparency can go a long way in potentially avoiding that type of court battle.
Great, thank you. So here's another one that I got through email. Would you recommend myself and my 2 daughters for POA for my husband? So really what she's asking is the pros and cons of a 3-person POA.
Sorry, can you read the question again? It would be, what was
it? So this person is wondering if 3 people as a power of attorney, so it would be herself and her 2 daughters. What are some of the pros and cons of having 3 people as power of attorney, or can you?
Okay. So I think I actually talked about this a little bit in terms of having joint agents, in terms of having of 2 people and the pros and cons. But just sort of to review, I think 3 people would definitely be very cumbersome. And in terms of needing things to be signed off on, if, for example, a financial institution wants you to have 3 people sign off on a document. So I would probably, my inclination is to say that it's not a good idea, and probably to dig a little bit more into what it is they're trying to achieve by that. Is it that they just want everybody to have equal say in the decision making? Is it a convenience thing where they want each person to be able to access accounts if needed, and probably try to figure out what a better system might be?
Okay, and also just a follow up from there, although I'm not, this may be a little bit too deep for today. Okay. A reverse mortgage for surviving spouse on a home.
So I'm not sure what's the question. Can the person,
like, is that a good idea? I think that was all it says. So more like, can we do that?
I think that that's probably a little bit outside the scope of this presentation,
Okay.
but certainly if the person wants to email me, I think you're going to have my contact information.
Yep.
I can
I'll,
certainly
I'll
get into that.
I'll pass it along to
Okay.
you. Okay, so now let's go into, there is a ton, so I'm not, again, sure if we can cover all of this.
Okay.
So what's the effective date of a power of attorney? Now, does this go back to the springing versus immediate?
Yeah, so I think that's covered by springing versus immediate. So springing is effective upon a finding of incapacity, and by a doctor determining that the person's legally incapacitated, whereas the durable power of attorney is effective right upon signing.
Okay. Let's see here. If my father is only receiving Social Security and has no assets, does he need a POA since the other is only one bank account, which I am joint owner of with my father to assist him and pay his bills?
So, although, the short answer to the question is, I think yes. I think it is still a good idea to have a power of attorney because, as I mentioned earlier, the power of attorney, it really is, there is a lot of broad powers. And so even though having a joint account resolves that issue of the person needing to access funds. As a joint owner, you'd easily be able to, for example, pay the person's bills because you have access to the account. I do think that there are other issues, and I can't think of any good examples right off the top of my head right now, but there could be things that the person needs to do. For example, maybe they have, you need to get statements from, another older bank account that's been closed, or need to, apply for something, or even have certain legal rights. I think there's a lot of different things that could come up that it would still make sense, even if you're not going to be using that document for that example that I've sort of been using in terms of the bank account access.
Okay. All right, so I'm gonna just keep going down the list here. Is the Massachusetts durable power of attorney legal in other states?
So that's another good question. So there is, in terms of, what you mean by legal, you can certainly, we draft our Massachusetts, power of attorney based on, Massachusetts law. And so even, for example, like I said, in different states, things can be called different things, like a financial power of attorney versus a healthcare power of attorney, whereas in Massachusetts, the language we use is power of attorney and healthcare proxy. So there's certainly nothing that would prevent you from using a power of attorney. You could certainly attempt to use it in a different state, but just based in terms of what that state's laws are, the way that they, the way that things are done there, it's possible that you might have, run into more difficulty depending on that state. So certainly we have lots of people that come to Massachusetts. For example, they might have a loved one that's going into a facility. The person already is incapacitated, but they have a power of attorney from another state, and that's certainly a lot better than not having anything. But if you are moving into a new state and you do have the capacity, it would definitely be prudent just to update it. And again, I mean, these are things that probably make sense anyways. One thing that just thinking about in terms of updating your power of attorney is that now our current powers of attorney have a lot of language regarding digital assets and email access, and all sorts of things that they might not have had 10 years ago. So in all cases, it makes sense to update if possible. But if not, it certainly helps to have something, even if it is from a different state.
Okay. Wait, let me see what this you know what? We're gonna have to save that one because I can't fully make that one out. Does the POA have to be registered or just witnessed by 2 or more third-party folks?
So it doesn't have to be registered anywhere. It's not something that would be, well, I should clarify. The power of attorney, if you're transferring real estate, it may need to be recorded with the Registry of Deeds. But once you sign a power of attorney in terms of setting aside that real estate issues, it's not something that gets registered anywhere. In terms of sorry, I just lost my train of thought. In terms of the signing procedures, we do our powers of attorney with 2 witnesses and a notarization, because the notarization is required for real estate. And so if you are going to be using it for real estate, you do want to have that. But yeah, so I mean, I guess, sorry, sort of the bottom line would be that the best practice would be the 2 witnesses and notarization, but that it does not need to be registered.
Okay. All right, and I think this should be the last one, and I'll follow up with these other ones with you, Sarah, after. Can an individual with the power of attorney change the mailing address of the individual over which she has power of attorney, especially in the case of an individual who may have dementia and be a resident in an assisted living facility? This would especially pertain to organizations providing tax-related information such as Social Security.
So a power of attorney does generally, and of course, you have to reference the document itself, but a power of attorney does generally have, as part of their powers, the ability to forward mail. So it wouldn't really be, I don't think necessarily that it typically would do a change of address, but instead have a forwarding to the person serving in that role.
Okay. Okay, so there are a few more, but I think we're basically out of time now. So I just want to say thank you.
Great, yeah.
Yeah, no, and I know Sarah's very good about answering and following up with all of these, so I will make sure that she gets these questions so she can try to answer the rest of these for you. And I just want to say thank you to you, Sarah, Tony. Thanks for inviting us to be part of this, and we are going to have a recording of this, so if you have to go back for your notes, that's you can have that within the next week. And and then just further, just so that you have it, this is Sarah's direct contact information if you have additional questions. So look at the sh@margolis.com if you have additional questions, okay? And with that, I just want to say thank you and hope everyone enjoys the rest of the day.
Thank you.
Great.
Thank you,
so
Sarah.
much. Thank you, Tony.
Thank you.
Thank you.
All right, take care.